A five-judge bench in the Supreme Court delivered an unanimous verdict. Here is how to break it down. The first question: why did Ramlala Virajman get the title of the land so that a trust can then build a temple upon it? Now, Ramlala Virajman was representing the deity Lord Ram. A deity is always represented through the next friend or the guardian. Ramlala Virajman could assert its title by way of continued worshipping of that land even when a three-domed structure, the Babri Mosque, stood. Supreme Court took into account the fact that even when there were namaz being offered, people were standing outside the railings, treating this to be the birthplace of Lord Ram and offering their prayers at it. How did the deity's right been acknowledged here? Now, deity Lord Ram, Supreme Court has said it in multiple judgments in the past also, that deity has a right, deity is a perpetual minor, deity's right can be executed, can be asserted through either the next friend or the guardian. Ramlala Virajman in this case happened to be asserting that very right. Now, deity's right has already been acknowledged by the Supreme Court. Today's verdict finds a reiteration of that right when it said that Lord Ram in all the sense has the title of the disputed land itself. Now, will this judgment have any impact on Sabrimala? I would not want to make a second guess on that, but yes, there are two differences and two similarities. In Sabrimala also, there is a question about the right of the deity, that it is the deity's right which the worshippers are trying to protect by preventing the women of menstrual cycle to enter the temple. But then the character of the deity is something which the Ayodhya verdict has not ruled upon. In that case, Sabrimala, the idol, is supposed to be a Nashtik Brahmachari. Here there was no question about the character of the deity. So although there is similarity, worshippers are trying to assert the right of their god. Through this court, the constitutional court, the character of the deity was never in question in the Ayodhya verdict. Will this judgment have any impact on the other clamor about Kashi and Mathura temples? Now, I would say that there is a 1991 Act, Place of Worship Act, which did exempt Ram Janmabhoomi Babri title dispute of its ambit when it said that anybody who will try to change the religious nature of any structure which stood as on 15th of August 1947 will be a punishable offence, with which, and this law is going to prohibit anybody else from trying to either offend any other religious structure or to stake its claim that something else existed, predated underneath a religious structure as it stands today. In some other interesting observations by the Supreme Court which helped Ramlala Virajman stake claim over the disputed property was the Archaeological Survey of India's report. Now, that report, the Supreme Court said, cannot be dismissed as being just conjectures. Supreme Court went on to say that this report did establish a few facts, including that there was a predating structure underneath the Babri Mosque. This structure was non-Islamic in nature, it belonged to the 12th century, and the artifacts and other engravements on the pillars found would go on to show that it was basically a Hindu religious structure. This was something which was corroborated as an evidence when Ramlala Virajman tried to say that Babri Mosque stood on a Hindu structure. Then the travelogues and the gazetteers were also relied upon by the Supreme Court when it said that there has been a proof of continued worshipping of that place and that the people believe that this place is the birthplace of Lord Ram. In another very interesting aspect about the judgment, every judgment of the Supreme Court will have the name of the judge who has authored the judgment. This was the unanimous judgment, but then this judgment did not carry the name of any of the judges. It was just a judgment which is supposed to be authored by all of them together. Despite that, there is an additional judgment in it. In that judgment, the particular judge, one particular judge, goes on to hold that yes, in my opinion, that particular place is the birthplace of Lord Ram. But very interestingly, even the name of that one judge has not been put into public domain by the Supreme Court, which will go on to indicate that Supreme Court would wanted to tell the public, the people in India, that this is the judgment by the Supreme Court, the highest court of the land, and not by any particular judge. How did Article 142 come in the picture? Under 142, Supreme Court has the inherent jurisdiction and the authority to deliver any order to meet the ends of justice. This is an exercise of an extraordinary jurisdiction by the Supreme Court under Article 142, by virtue of which Sunni Waqf Board has been given 5 acres of land, saying that they have also suffered wrongs by being ousted and also by demolition that took place in 1992. Supreme Court said that equity would demand that Sunni Waqf Board should be given 5 acres of land in Ayodhya, either by the central government or the state government. Ayodhya verdict by the Supreme Court today looks at giving finality to one of the most contentious and longest pending dispute in India's judicial history. So Supreme Court in its judgment has tried to accommodate all the parties and has said that secularism and to live in harmony is what each and every citizen of India must look forward to, and should also respect all the constitutional principles that is there, and the constitution speaks through the judges is what the underlying principle of this Ayodhya verdict is.